This courtroom opens with something judges absolutely hate to hear. It just happened. We're dealing with a defendant who admits to theft, admits it wasn't an accident, and yet struggles to explain how a habit of stealing even forms. Right away, this sets the tone not just for guilt, but for credibility. Because in court, credibility is currency. Lose it, and every explanation that follows gets put under a microscope. This case isn't just about stolen tequila or missed probation check-ins. It's about patterns, repeated choices, and whether the court believes this is someone who made mistakes, or someone who keeps testing how far they can go before consequences finally stick. And when the judge starts asking how the money was spent, clothes, nails, grills, you can feel the shift. Because now, the story of "I needed rent" is colliding head-on with documented lifestyle choices. Stay with this one, because what begins as a theft discussion quickly escalates into probation violations, revocation risks, and an ultimatum no defendant wants to hear: jail now or jail later. And trust me, when a judge says, "These are your only choices," they mean it.
All right, so this is the third time she's probably learned her lesson from stealing. Why do you keep stealing?
Before I wasn't in a better position than what I am now, and that was something that I picked up in a bad habit.
What, a bad habit of stealing?
Yes.
How do you develop a habit for stealing?
It was just something that I chose to do. It was a choice. And
But I'm just trying to figure out, how do you develop the habit for stealing?
It just happened, and
Well, did you all plan? Did you all say, "Hey, let's go to Don and Ben's and take tequila"?
Yep.
No, it wasn't anything like that. Like I said, I was in a bad predicament, and I was using that to like pay rent or do any, just.
It was at this moment that she knew she fucked up.
Making any
No, I don't know. Because, and let me just explain to you why I don't realize that.
Understand.
Because people will spend money on their wants, but not on their needs.
Right.
And what I'm reading in here, everybody in the vehicle was dressed to the nines. So obviously there was money for clothes, there was money for hair, there was money for nails, there was money for gold, there was money for gold grills, but then people are saying they're stealing for other things that I don't understand.
Right.
This is a crucial judicial moment. The judge isn't debating whether theft happened. That part is already clear. What's happening here is something deeper. The court is dismantling the justification. When a judge contrasts claims of financial hardship with visible spending on clothes, hair, nails, and gold, it's not to shame, it's to assess truthfulness. Courts don't punish poverty. They punish dishonesty. And notice how specific the judge gets: marijuana odor, the number of tequila bottles, the brands remembered clearly. Memory matters. When someone remembers details that conveniently support one version of events but claims confusion on accountability, judges take note. This isn't anger, it's evaluation. Here's the question for you watching. When someone says they stole to survive, but evidence shows discretionary spending, should the court be sympathetic or skeptical?
And then going to Don and Ben's, the officer said that the car smelled of marijuana, and you all just went to Don and Ben's grabbing tequila. So I don't understand when people say, "Oh, I needed rent." Who's out here buying stolen tequila?
I don't smoke, so I don't know.
No, I said, who's out here buying stolen tequila? Did you take orders where you just say, "Hey, anybody want tequila?" Because it's saying that you took
6 bottles.
yes, of tequila, 2 coconut bottles, reposado,
Yes.
and
Regular.
yeah. So see, she remembers. So why? So that you all could drink and have a good time. How old are you?
I'm 28. I was 7 then at the time, and that was just how I was making my money. There's no excuse for it. I'm not making no excuse for it. And like I said, that's something that I'm not doing anymore.
At this point, the defendant admits something that carries serious legal weight. She wasn't just stealing, she was reselling. That changes the narrative completely. This isn't impulsive theft anymore. It's organized behavior. And while she says she's not making excuses, intent matters. Selling stolen goods moves this from desperation into enterprise. Also notice how the judge tests consistency. Brands remembered, quantities confirmed. This shows the court is assessing mental clarity and awareness at the time of the offense. That matters later when determining accountability and sentencing. This moment quietly closes the door on, "I didn't know better." The court now knows she did.
Is this still going to be a contestant?
No, Your Honor. He's going to enter a true plea. We have an agreement with the court settling his position.
Okay, I need a trial court certificate.
Just have a seat.
Oh, she can remain here and you
Okay.
can just go grab it. All right, they're going to go get that. While she's getting that, we'll begin. Court is calling 2024 CR 008663 State versus Imani Robinson. Can I have parties announced?
Galloway for the state.
David Andre Woodard from Ms. Robinson.
And are you Miss Robinson?
Yes, ma'am.
If you review the documents entitled Motion to Revoke Community Supervision and First
We're on the
Amendment
record.
Motion to revoke community thank you. To revoke community supervision with your attorney, did you understand it? Okay. Are you the same Imani Renee Robinson who was placed on community supervision in 2024 CR 008663 for the offense of theft of property less than $2,500 with 2 or more convictions on December 5th, 2024 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Violation of condition number 4 in Bexar County, Texas. The defendant, Amani Renee Robinson, did then and there fail to report to the supervision officer as directed for the months of May, June, July, August, September, and October 2025 in violation of condition number 4.
How you plead to that, true or not true?
True.
This is where the case pivots from what happened to what went wrong after. Failing to report to probation isn't a technicality. It's a direct violation. And pleading true is a massive decision. When you plead true, you're essentially telling the judge, "I did this, and I accept the consequences." The judge clearly explains the risk. Up to 2 years in state jail. That explanation isn't required for drama. It's required for fairness. And once the defendant confirms she understands, there's no undo button. Everything that follows now is about mercy, not innocence. This is the tightrope probationers walk. One misstep can collapse years of opportunity.
Judge, we would abandon the remainder.
Any objections?
No objections, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 2 years in the state jail facility and up to a $2,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Judge, this is the defendant's first MTR. We are asking that the court deny the state's motion and alter and amend her conditions to include the hostility management course and a no contact order with Taylan Mackey, and that is TALIAN MACKEY.
All right. So why hasn't she reported?
Judge, when I spoke with Imani regarding not reporting, I think what happened is the new offense had occurred. She knew that she would likely have a warrant, and I think she got fearful of reporting to probation. So instead of doing what she should have done first, we're here now in this motion to revoke with months of not reporting. As the state mentioned, this is her first MTR. She has been on GPS monitor since the court set a bond for her, and she's had no issues on the monitor. So we're respectfully asking the court to follow the state's recommendation and try to get Ms. Robinson back on track.
This is defense strategy in action. Counsel isn't denying violations, they're contextualizing them. Fear, a new offense, avoidance, and importantly, GPS compliance. That matters. Judges care deeply about supervision compliance, and a clean GPS record gives the defense something tangible to stand on. The argument here is simple. Don't throw away probation, restructure it. Add conditions. Apply pressure without full revocation. And this is often where judges decide whether someone still has a future in community supervision, or whether incarceration is now inevitable.
So she can successfully complete her probation.
How old are you?
29.
All right, I'm gonna give you a choice. These are your only choices. There are no other choices. One, I can revoke you, and if there's no objection, I'll sentence you under 1244 to 300 days in the Bear County Jail. Or two, I continue you, and as a condition of your probation, you're gonna do some jail time. And it'll be 30 days jail. Which do you prefer?
This is one of the most intense moments in any courtroom. The forced choice. No negotiation. No third option. Judges do this when they believe the defendant must confront consequences head-on. Notice the framing. 300 days now or 30 days plus continued probation. This isn't cruelty. It's leverage. The court is measuring whether the defendant wants structure or freedom with responsibility. And hesitation here speaks volumes. Silence in these moments is loud. Ask yourself, if you were standing there, knowing your past choices got you here, which option would you choose?
You need to discuss that with her?
I would like to, Judge, before she makes a decision.
All right, thank you.
Let's go ahead and see.
And say, I'm sorry, I'm making an assumption you have no objections if they choose the 1244 route. All right. So counsel, what has your client decided?
Which decision are you going to do? Tonight?
On the record, let's keep it down.
30 days and continue, like 300 days.
I want to be my 300.
All right. Oh, do you have the,
I think you have turned it into your clerk.
all right, can I have a trial court certification, please? All right, court is finding violation of condition number 4 true. Court will sentence you under, well, the court will revoke. Sentence you to 300 days in the Bear County Jail under 1244. Give you credit for any time served. There's to be no contact with Don and Ben's, BEN''S. There's to be no contact.
The decision is made, and it's not the lighter one. The court revokes and imposes 300 days. This outcome tells us the judge wasn't convinced probation would be respected moving forward. The no-contact orders are also key. Courts don't issue those casually. They're meant to sever environments linked to criminal behavior. This is accountability in its most direct form. No theatrics, no lecture, just consequences.
With Talon, I believe it's Talon McKee.
I believe that was the name the state put on the record, Judge.
All right, is there anything else with regards to sentencing?
No, Your Honor.
All right, let's review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it and did you sign it?
Yeah.
Yes or no? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thanks, Judge.
Thank you.
Judge, you're taking her to custody, right?
Yes.
Oh.
And I don't know, counsel, if she has anyone here that she has things she would like to give to them.
Yes, I thought I said, we're gonna do that.
And are you Ms. Tanahara?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision and state's motion to supplement pending motion to revoke probation with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Adriana Tanahara who's placed on community supervision in 2017 CR 13698 for the offense of forgery of a commercial instrument or check on August 3rd, 2018 for a term of 4 years? Is
Yes,
that you?
ma'am.
All right, state.
Violation of condition number 38. On or about the 25th day of August 2020 in Bear County, Texas, the defendant Adriana Tanahara did then and there fail to participate in the felony drug court program in violation of condition number 38.
How do you plead to that? True or not true?
Not true.
State.
We waive and abandon the remainders.
Any objections to the waivers?
No objection, Judge.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, sentence you to 2 years in the state jail facility, and up to a $500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 38?
Yes, ma'am.
Now we transition to a second defendant, and a very different type of case. This one revolves around long-term noncompliance, drug court failure, and financial obligations dating back years. The phrase "since 2018" should ring alarm bells. Time matters in court. The longer someone avoids responsibility, the harder it becomes to justify leniency. And when medical issues enter the conversation, the court listens, but medical hardship doesn't erase years of inaction. It explains, but it doesn't excuse.
Court will find violation of condition number 38 true. Is there a proposed agreement?
Judge Estate is asking for revocation and a sentence of 1 year in the state jail facility.
And Judge, that is our agreement, if I may speak on behalf of my
Yes.
client. Ms. Tanahara was originally placed in the drug court program. She was having financial difficulties with participation. When she was removed from the drug court program, she started to have medical issues, congestive heart failure. I have some documentation of that congestive heart failure if you'd like to review that. As her medical condition got worse, she became more and more concerned about turning herself in because she wasn't going to get her medical treatment. She understands that this was not the appropriate way to handle this, and that because of that, she only can be either terminated, unsatisfied, or revoked. But she is here wanting to take responsibility, and I do think she wanted to address the court really quickly if she
Okay,
may.
do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Adriana Tanahara.
All right, your attorney mentioned something about financing.
Yes, ma'am.
How was that related to drug court?
I was just unemployed. I wasn't applying myself as I should have been, and since then,
No. Because it seems as though maybe a conversation that you've had, you're saying that you had issues with finances and felony drug court. And normally felony drug court does not require you to pay the $1,000 fee until you're closer to graduation. So I'm wondering, just so I'll know, what finances are you saying you had difficulty with in felony drug court? Because they help you
No, I
with
didn't-
employment.
and not in the drug court. I had it
No.
in the program, I guess, that they offered me
What program?
my probation officer had called me and told me that there was a program I could pay off my fees in a certain amount of months. And
What program?
I don't know what it was called.
So two things, Judge. How I was addressing the drug court was that she was not able to provide for herself, not provide for the drug court because of financial issues. So that's issue number one.
Yes.
And then issue number two is that according to my client, the felony probation officer told her that if she was able to just pay off her fees, they would terminate her from probation. I know that that's not necessarily the way that it works, but that's how it was discussed with her. And it's not the first time I've heard that being discussed with the client. So I think just for court's clarity, I think that's what she's speaking about.
Okay.
And let me give you the documentation on the medical.
And then my other question is, it said that you owed $743.99 to HEB. Has that been paid?
Yeah, ma'am.
I'm sorry?
No, ma'am, not yet.
All right,
It was
you've
this week.
had since 2018 to pay that. Why hasn't that been paid?
I wasn't always employed, but it was my fault.
But I mean, it's since 2018 and you haven't paid a penny to that?
Um, take
That's a problem.
responsibility. Yes, ma'am.
And then this is not your first motion to revoke. That's a problem.
Understand.
So what what have you done? Have you done anything other than this is your second motion to revoke?
I've just got employed. I mean, I've just, been.
I mean, if you haven't done anything, I mean, just tell me.
No, ma'am, I haven't done anything towards the courts. You're right.
Because you were placed on probation before I was presiding judge in this court. And then you had a motion to revoke, and it was violations of 5 and 5. And according to this, you have children. That's why I told you to do parenting classes.
Right.
And it appears you haven't done anything since 2018.
Sorry.
I mean, I don't even know. Somebody explained to me why I should give you a year instead of 2 years because you haven't done anything.
I guess the basis of our request is the congenital heart failure and the medical treatment that you would receive in the state jail facility. She hasn't done anything towards the court, but she did at one point receive gainful employment, and that was a huge struggle and a huge hurdle that had to be overcome by Ms. Tanahara. I think you can see based on her drug court participation, as well as even the medical documentation, she is a methamphetamine addict and has struggled with addiction for quite some time. And so even just getting gainful employment was a feat in and of itself.
And who's taking care of your child?
I think it's her mom. Is that
That's my sister.
your sister? And they're here, Judge.
So does anybody want to tell me why I should just give her a year? She hasn't done anything.
This is one of the judge's strongest moments. The court isn't questioning addiction. It's questioning effort. You haven't done anything is a devastating assessment. Judges want to see attempts, even if imperfect. Employment, partial payments, program participation, something. And here's the reality. Repeated motions to revoke signal that prior chances were already given. Courts don't measure promises. They measure patterns.
I mean, not even paid towards HEB since 2018.
And so our request would be based on the medical issues, as well as the fact that she did seek gainful employment. We understand that this is not the way Ms. Tanahara should have handled this. She understands that.
State.
Judge, I did take into consideration the medical issues, which is why the state is asking for 2 years of this.
All right. Are you asking me to follow this revocation for 1 year?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, this is what the court will do. The court is finding violation of condition number 38 true. The court will grant the motion, revoke, sentence you to 1 year in the state jail facility. Give you credit for any time served. There's to be restitution to HEB in the amount of $743.99. And that's under cause number 2017 CR 13698. There's to be no unsupervised contact with minors. And the court will request the therapeutic community for you. Therapeutic community doesn't increase the amount of time that you will serve, but it is designed to help you with any addictions you may suffer from.
On my way out of my room.
During that the therapeutic community is in the state jail facility.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. With your heart condition, if you continue to use, meth is not great for the heart to begin with, not even on a healthy heart. One or two things going to end up happening. Either you're going to be in and out of jail or in and out of prison for the rest of your life, or either you may get a bad batch or it may hit your heart a certain way and somebody's going to have to identify your body. If you're not going to be clean and healthy for yourself, then do it for your child if you love your child. And when you're released from the state jail facility, don't come to your sister's home acting like you've been the parent all the time and you're setting your own rules. You're going to need to flow with the way the household is set up. Do you understand?
Yes, ma'am.
All right, when you're released, if you cannot find a place to help you with your sobriety, any type of transitional home, if I'm still here, you come back here, I'll pick up the phone, call a place to help you, all right?
Appreciate that.
All right,
Thank you.
good luck to you, okay?
Thank you.
You're welcome.
This courtroom session delivers two clear lessons. First, probation is not passive, it's active responsibility. Missed reports, unpaid restitution, and avoidance stack up fast. Second, courts will consider fear, addiction, and medical issues, but only alongside demonstrated effort. In both cases, the judge balanced fairness with firmness. One defendant lost probation entirely. The other received a reduced sentence, structured treatment, and a final warning rooted in concern, not punishment. And now we want to hear from you. Backhand index pointing right, were these rulings fair? Backhand index pointing right, should the court have shown more leniency, or was this accountability overdue? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.